Hello,
negotiate.
Beckwith. Again, I think two related questions. The first, how can one introduce a natural law perspective into the actual practice of law? And conceptually, I think related to it, how would the author of In Defense of Abortion answer the following question? What do you mean by the phrase morally permissible?
Thank you. Let me answer the second one first. I think what David means by morally permissible is just anything that that you have a right to do, but you're not required to do. So morally permissible just means that it's not wrong to do it, but you're not required to. So for example, if I choose to eat a turkey sandwich rather than a ham sandwich, that's morally permissible. But if, let's say, I decide to take my turkey sandwich and throw it at you because I just don't like you, that would be morally impermissible. However, if you were coming at me, let's say with a sharp plastic knife, and I threw the sandwich at you in self-defense, that would be morally permissible. So I'd probably give too long of an answer for it. It's a pretty simple question. But the first one about how do you incorporate natural law into the practice of law, I'm not sure you can in any way other than probably in areas of professional responsibility. That is, most of the rules of professional responsibility for lawyers are actually in many ways grounded in natural law reasoning. That is, you have an obligation to your client, and you have certain obligations to treat that individual with respect. I mean, so those sort of things find themselves in the practice of law. Now, in terms of the more general question of where does natural law fit in, let's say with constitutional law or statutory law, I think it's a little bit more complicated. In some ways, our Constitution reflects a natural law understanding. I mean, one in particular, and some of you may know about this, but during the American founding, there was a great debate about whether to include a Bill of Rights. And the reason had nothing to do with the fact that they didn't think there were rights or natural rights, is that some of the founders thought if you wrote them down, it gave people the impression you could erase them later. And so the thinking was that if you wrote that, for instance, this is not in the Bill of Rights, but there's a section in the Constitution that prohibits post facto law. That is, you can't pass a law, a criminal law, and prosecute someone after they commit it. Right? I mean, this is, and some of the founders said we shouldn't put that in there because what if a future generation amended the Constitution to allow post facto law? Because it's so obviously against natural law that we shouldn't even write it down. So there was a kind of understanding among the founders that if they were hesitant to put too much written down. And I do think that much of the Constitution, especially the separation of powers, accepts a kind of, I think, a largely Christian understanding of human nature, that human beings are not to be trusted with too much power. So the best way to make sure that we don't have despotic leadership is to make sure that there's a lot of gridlock. Gridlock is good. That's a principle of the American founding, by the way. I just made that up, but that's actually, I mean, largely their view is that if it's difficult to pass laws, it means it's going to be difficult to control people, and so that's a good thing because no one's to be trusted. I mean, many of the founders were deeply influenced by a kind of Reformed Calvinist understanding of total depravity, and they believed it, and so that's why I think you have in the Constitution this view. But all right,
we're going to conclude with another two related questions. I think related because they are classic arguments, and it would be very interesting to hear the response from Professor Beckwith, and again also to invite you to ponder the answers yourself, hopefully with clear reasoning. But first, what about the argument that to outlaw abortion is to impose involuntary servitude on pregnant women? And a very famous one. What do you do when someone says that abortion is justifiable in cases of incest and rape?
Thank you. Let me first respond to the involuntary servitude argument, which actually, there are a few people that make this argument. I'm trying to think, Andrew Koppelman at at Northwestern University Law School actually is one of the few people that defends this argument, saying that to require pregnant women to carry their children to term violates the 13th Amendment's prohibition of involuntary servitude. A couple of problems with that. First off, who is the pregnant woman serving? I mean, ask that question. In other words, if let's say the federal government allows involuntary servitude, let's say slavery, right? And I have to be a slave to you, okay? And so there's the state permits it, but who is she serving, right? Let's assume that it's the fetus, right? Now, even if you think it's involuntary servitude, that doesn't give one a right to kill the person that's enslaving you. So even if, for the sake of argument, we were to say that it was involuntary servitude, it doesn't follow that the remedy for that is to kill the owner. Okay, so on one level, so even if we were to grant that understanding, it would be mistaken. I think it doesn't follow that abortion is justified. So even if Andrew's right, yeah, it's involuntary servitude, it doesn't mean that the remedy suggested would follow. Second problem with it is that it, in some ways, I think misunderstands and diminishes the relationship between parent and child. I mean, imagine if, let's say, there's a man, a gentleman, father, who is a mechanic, sires a child out of wedlock. The woman goes to court, the mother, and says, we want to, you should pay child support. He refuses. The state then requires for the next 18 years that it garnish his wages so that they can pay child support. And he says, that's involuntary servitude. I've got to now work, say 20% or 10 to 20% of my income for the next 18 years. I'm working for this kid. Why isn't that involuntary servitude? It's actually fewer than 9 months, right? It's 18 years. And he's got to lift heavy equipment, take out oil, change, pistons and engines and all these things. He engages in physical labor for 18 years. And nobody would call it involuntary servitude. Why? Because fathers have an obligation to care for their children. There's a relationship between parents and children that differs dramatically than between strangers. And one of the problems with this sort of argument, and you find this a lot in our contemporary world, is the turning close relatives into strangers by law. One example, and I know that there's the other question, but I want to just pursue this for a few seconds. It's one of the weird things about our culture today. If somebody were to say, let's say, I don't want to pay higher taxes. Let's say somebody says this. I'm not saying this is my view necessarily, but if somebody says, I don't want to pay higher taxes to support the welfare state, somebody will say, you lack compassion. And then somebody else says, let's say somebody says, I think I should have an abortion. And somebody and say, well, and let's say I oppose it. Somebody says, you lack compassion. Now the weird thing is that essentially that type of reasoning says, I have a greater obligation to a stranger than I do to the child, or that this woman has to the child she's carrying. There's a way in which our law kind of twists ordinary understandings of parental relationships and relationships with strangers that is, I think, ultimately undermines the family. And so you have, on one hand, the person who, let's say, doesn't like paying too many taxes for the welfare state says lack compassion, but that same person says, I want an abortion, but no, you would never hear somebody say they lack compassion for their own child. And so the weird thing is that we have a culture that says we have a greater obligation to care for the children of strangers than the children in our presence. Which is a very weird, I think ultimately a weird way of thinking. So the other question concerning rape and incest. This is the way it's a very difficult question to answer, not because it's logically difficult, but because it's emotionally difficult. And the way that I've dealt with it in the few times that it's been posed to me in debates is this. If there were, this is what I usually ask the person I'm debating, if there were no cases of rape or incest, would you still be for abortion rights? And they usually say yes, and I said, then why do you bring it up? It's not relevant to your case. Now, it's a kind of, it's a little bit of a rhetorical trick, but the attempt is to say, look, you believe that all abortions are justified because the fetus is in fact not a person. If that's the case, then it doesn't matter whether they're a case of rape or incest. Now, from my position, how would I, let's supposing there was a law that was going to be passed that would, let's say, that would forbid abortion except for in cases of rape and incest, and supposing that's the best I could get, I may very well support that law, not because I think that abortion in those cases are permissible, but because that's basically the best I can get. Now, the problem legally is that courts would say, well, why are you distinguishing between the unborn children conceived in rape versus the unborn children not conceived? And of course, that becomes a very difficult issue, especially if you want to ground the prohibition based on the fact that the unborn is a person. Because you can't say that you have a right to kill a person because its father was a rapist. And that just, so there's a problem, I think, in terms of the courts. But that's the way I respond to it, is to sort of get people back to the question of whether the unborn is a person, and then we can then address the question, the difficult issues that are indeed rare, but they do happen. They do happen. So that's how I would respond. Thank you.